So, this is how a judge would intervene between the disputing parties and send them to any of these authorities. Now, bringing back to the topic that we are discussing, speedy and amicable settlement, I must classify section 89 as both speedy, ensures speed as well as ensures amicable settlement between the parties. So, section 89 is the most important section when it comes to the topic of speedy and amicable settlement of dispute. There are quite a few judgments relating to these section 89. The Salem Advocate Bar Association versus Union of India, the court looked into the object behind the act, behind the section 89, and it is mentioned that dispute not always need to be decided by the court, and this should be understood by the judges under all circumstances. So, as this the decree is not the only way to resolve dispute, they should encourage these alternative methods. And when you encourage alternative methods, it has got two advantages. Advantage number 1, answer to the question of docket explosion, and even more importantly, answer number 2 would be protection of relationship between the parties. Salem Advocates Bar Association also made an interesting comment upon outside the purview of the court and inside the purview of the court. Now, section 89 operates at two spheres. One sphere goes out of the purview of the court, and that sphere is arbitration and conciliation, because they are governed by Arbitration and Conciliation Act 1996. Within the sphere of the court are the remaining three, that is Lok Adalat, judicial settlement and mediation, because these operate within the jurisdiction of the court under Legal Service Authorities Act and mediation rules prepared by the court. So, this is what the Salem Advocates Bar Association has to say. In 2010, another important judgment came, that is Afcons Infrastructure Limited versus Cherian Varkey Construction Company. This is an important judgment because it has made series of comment upon the faults that lie with drafting of section 89. So, when you look at section 89, the Afcons, in Afcons the Supreme Court felt that ADR is not being followed frequently as expected by the parliament when they introduced section 89. So, the Supreme Court feels that the legislature's desire to have ADR has not been met properly by the courts. At the same time, they also say that section 89 looks to be mandatory, that all disputes should go through ADR processes, but actually when it comes to implementation, it cannot be mandatory, because it is the discretion of the judge to decide to refer it to ADRs. So, when you say discretion of the judge has to decide two things, that is whether it is a suitable matter to be compromised, because there are disputes which cannot be compromised at any stretch of imagination. Secondly, whether parties are in a mood to compromise the dispute. So, both are at the discretion of the judge's opinion. So, once he forms an opinion, then he makes the reference. So, when I said that the matter which cannot be referred to ADRS due to as the matter itself is not suitable for resolution of dispute, the court gives few examples like representative suit, order 1 rule 8 of CPC. Now, representative suit is a suit where one person is representing numerous people, a similar kind of PIL with slight distinctions. When one person represents numerous people, he is not allowed to compromise, because it is not only that he is compromising his right, he is compromising others' right also indirectly. So, therefore, he is not allowed to compromise, and in turn therefore, section 89 doors are closed for representative suits. Secondly, the dispute relating to election to a public office. This is a constitutional right. Holding on to public office through election process, constitutional rights cannot be negotiated, cannot be compromised. It has to be decided by the court by application of strict principles of law. Then grant of authority by the court after inquiry. So, when we talk about authority to act upon a thing, now let us say the surroundings of Delhi, who can conduct the developmental activities around Delhi? Is it housing board or is it PWD? Matter has to be decided. It has to be decided after conducting a proper inquiry into the legislations and rules and regulations, and it cannot be compromised. Serious allegations of fraud, it does not make any sense to compromise over those issues, because it is unnecessary to go through the fraudster to expecting him to resolve the matter. Cases requiring protection of courts, the disputes where the parties are in a position to destroy the subject matter of dispute, or in other words where the parties are putting subject matter of dispute under threat, there section 89 should not be encouraged. It surely should go through the judicial process, plus with immediate order for interim measures on protection of the subject matter of dispute. And criminal offences, definitely it cannot be negotiated, definitely it cannot be compromised. And while giving this list, court also mentioned that this is not an exhaustive list. Some more disputes can also be non-negotiable and unsuitable to resolve. But there are various disputes which are suitable for the process, like trade, commerce and contract. The dispute relating to trade, commerce and contracts are the best disputes which could be resolved through negotiation process, because here relation is important rather than the immediate profit or loss. When you have a long term relationship, the profit could be the loss could be converted into profit easily at any point of time. Therefore, it is important to protect relationship, and ADR is the best way to protect a relationship. Where the relationship is strained and soured, ADRS can work as a balm to bring back the strained relationship into action. Then pre-existing relationship needs to be protected, ADR is the best way to deal with it. Tortious liabilities, ADR can do well, so therefore section 89 would be more preferred than court proceedings. Last but not least, the consumer disputes. The consumer disputes, again a dispute between two parties with a different economic status, negotiation can work wonders. Again, list is not exhaustive, it can be, the list can go on, new things could be added. In addition to this, court should use its discretion while exercising the right under section 89, and Afcons says that it should take into consideration the nature of dispute, interest of the parties and need for expeditious resolution of dispute. So, these three things should be taken into consideration before referring the dispute for section 89. And the procedure to be adopted, it should be left to the parties to choose it, and court has got right to interfere at right point of time. From section 89, I think I have done a lot of discussion on this. Let me move on to the settlement of issues. Now, this is another provision of order 14, where initial stage there is plaint, written statement is filed, suit is continuing. At the initial stage or at any later stage of the trial, the parties are permitted to submit an agreement saying that we are settling our issues. The issues may be settled as to question of fact or question of law. So, they may state the same in the form of an issue, and agreement in writing should be submitted to the court. And the court, if it finds it affirmative or negative on the issues, it can pass relevant order on these things. So, parties can come up with these issues of settling it during the trial, and it could be done by writing. In writing, by following the procedure under order 14. The sum of money specified in the agreement could be transferred with this procedure. As I mentioned under friendly suits, in the special suits, in the initial discussion, the same rights could be established through this settlement of issues procedure. The right over a subject matter, liability over subject matter could be established, could be diminished, could be extinguished through these processes. The delivery of property, movable or immovable, could be ensured through this process. Implementation, enforcement of prohibitory orders also could be done through these processes. So, from the settlement of issues, now I will move on to the withdrawal of the suit. So, when a plaint is filed, the plaintiff, if he does not want to continue with the matter, he can withdraw his plaint. When he withdraws his plaint, the dispute comes to an end. But is it an end of the dispute? May not be. It may be an interval for a dispute. The dispute is merely suspended, not completely dismissed. So, therefore, when we talk about the withdrawal of a suit, it is not an end to the dispute, but there is a provision where withdrawal is of two kinds. Withdrawal without permission of the court means you cannot come before the court again on the same subject matter, because you are withdrawing without the permission of the court. That is the end of the process. But if you withdraw with the permission of court, means you have kept the doors of the court open, you can knock the door at any other time and file the same subject matter before the court. The question is, why the distinction? Why permission without permission? The process needs to be explained, and here what happens is, some people may withdraw a suit because it is not properly stamped, court fee is not paid, jurisdiction is a issue, valuation is a issue. So, these technical defects can lead to dismissal of the suit. To avoid the dismissal, they may withdraw, that is with the permission of the court. So, again coming back to the topic, speedy and amicable, this may not address both the requirements, but definitely when it is withdrawn without permission, that is an end of the litigation. Compromise of a suit, again order 23 talks about compromise. When the trial is going on, parties are free to negotiate the dispute outside the courts of outside the walls of the court. So, there is issues are heard, trial is conducted inside the court, and negotiation is on outside the court, and both can run simultaneously. That is what compromise of suits talks about. Even there are situations where the court adjourns the hearing, because if they find that negotiation outside the court is going on well. So, once they satisfy the dispute, they can bring it before the court, and court shall record the matter, and once the court records, it passes the decree in accordance with the compromise arrived at. So, again before converting the compromise agreement into compromise decree, the court has got certain powers, and mind you, it cannot be done in a mechanical process. It has to be done through a judicious application of mind, because judge has to ensure himself that the agreement is in accordance with the law. The process of negotiation is also in accordance with the law. Now, let me take up the discussion on government suit. The primary duty of the state, as we all know, is the welfare of the people. And can you imagine a state which is for the welfare of the people fighting a case against its own people? That is what happens most of the time. So, how come a state government which is elected by us is fighting case against us? They are paying fees to the advocates through our tax money. We are paying fees to the advocate through our own money. So, how to avoid this situation, which is quite awkward? So, here order 27 read with section 80 of CPC says that the state should work for the welfare of the people rather than work against people in a litigation in the court. So, therefore, there is a provision to resolve a dispute by granting of 2 months notice to the state. The rule says that if anybody wants to file a case against a state, they have to issue notice of 2 months. And what happens in these 2 months? The state supposed to attempt to settle the dispute. They are supposed to negotiate and settle the dispute. They are supposed to investigate the mistake that they have committed and try to redress their mistake. So, that is the purpose of this 2 months notice, and that is the purpose with which the dispute could be resolved. And also there is a duty imposed on the court that when a state is a party to a litigation, it is the duty of the court to assist the state as well as the party to come up with a settlement of the dispute. And this attempt of the court would run throughout the proceedings, and they can do it at any stage of the proceedings. If the court finds that there is a chance of settlement of the dispute, court is permitted to adjourn the proceedings and encourage parties to go for settlement of the dispute. The next is family suit. Family is a place where disputes bound to exist, but the dispute not supposed to grow to the extent that the family itself comes to an end. So, therefore, love and affection between the family members needs to be protected, and conciliation, mediation can help in protecting this harmonious relationship. So, therefore, Order 32A of CPC provides for family suit proceedings where they encourage conciliation and mediation and resolution of dispute through this conciliation and mediation process. Family suit includes the disputes relating to matrimonial relief like validity of marriage, status of a person, that is married, unmarried, guardianship of a person, custody of any minor or other members of the family, custody of disabled person, maintenance, validity of the adoption. So, this way there are many issues that could be taken up as the process, including wills, the intestate death, the succession, all these matters could be heard under these provisions. So, concluding my presentation, I must say CPC has done its bit in speedy and amicable resolution of dispute between the parties. It is CPC which has provided us with so many provisions, and it is us, the people of India, supposed to utilize those provisions and bring an early end to the dispute. So, I must say that it is not the CPC which has failed us, it is we who have failed the CPC. So, therefore, there is a need to utilize the provisions of CPC and bring an end for a dispute. Speedy and amicable dispute is a possibility. Thank you very much.